All right. Good afternoon. My name is James Redford. I have the privilege of serving the people of the state as a judge of the Michigan Court of Claims and the privilege of being the assigned judge in the matters of David Krieger et al. Versus the Michigan Department of Environment, Great Lakes and Energy. It is Court of Claims 20-0094 and on. There are lots of case numbers. Today is January 22nd, 2025. The hearing that we're gathered for today was scheduled for 1:30 p.m. and I apologize that we had some technological difficulties, and my understanding is that we're up and running. Who from the Court of Appeals staff is our IT quarterback today? If you could identify yourself, that'd be great.
I'm going to ask Judge Jesse Team from the clerk's office.
Okay, thank you, Ms. Team. Appreciate it. And so, and then we have again, our court reporter is Mr. Robert Trudell. Mr. Trudell, it's nice to see you again. We had I had the privilege of serving with him yesterday. And we've got a few more lawyers this time, Mr. Trudell, so it's a little trickier for everybody, just as far as if a number of different folks are involved. I was provided a list by Mrs. Tomet of the following individuals appearing by Zoom: Theodore Leopold, Leslie Kroger, Sharon Almanrode, Rachel Flanagan, Megan Shannon, Kyle Jacobson for the mass tort plaintiffs, that the class action plaintiffs, Mr. Dubin and Ms. Fagan as well, or Mr. Dubin's here. Ms. Fagan, I don't think is here though, is she? No, she's not. Okay. Mr. Dubin is here in person. And then by Zoom, Pauline Kennedy and Timothy Takala. And then for the subrogation plaintiffs, Brandon Brown. And he's not here though, is he?
This case is not on fitness.
Okay, thank you. All right. And Daniel Pifko by Zoom. And then Assistant Attorney General Nathan Gamble by Zoom. Richard Kuehl by Zoom. All right, and then we've got our final participant. That's Mr. Thompson for the class. So, is anyone else, the screen that I'm looking at, I see 6 sort of boxes. I don't know if that means it's limited to 6 or if there are more than 6 people on. Mr. Cranmer is our security guy today. Mr. Cranmer, can you tell? Yeah, Ms. Team, anybody else on that I didn't indicate their name that you know of? See Mr. Takala, is that correct? Right.
Judge, there are a number of attorneys individuals in the gallery. I promoted those that were on your list and they may have declined. If anyone does need to be promoted, please raise your hand and I can add you.
Okay, we'll give it a minute here. This team is seeing any hands? Because I don't see what you're seeing, obviously.
I don't, Judge. It appears everyone that wants to be admitted is.
Okay, fine. Thank you. All right. So as I indicated, we were scheduled to start at 1:30. We're a little bit late and I'm sorry for that. The parties have briefed this, the caption of a pleading filed on December 20th, 2024 is plaintiff's motion supporting defendant's counsel Nate Gamble as a likely necessary witness at trial. This came to pass as a result of observations that I made previously and some scheduling orders that I issued that are a matter of record in the court. And this is the time and date set for the parties to be able to amplify the record from their perspective. I have read all of the pleadings. I have read most of the attachments. I'm not going to sit here and say I've read every line of every single email that was sent, but I've read the vast majority. I've also had the assistance of our very capable lawyers on the staff of the Court of Claims. I'm prepared to listen to the positions of the parties. I do not expect that I will be ruling from the bench on this, but I don't expect it's going to be something that's pending a super long time. I will indicate once we're done with our oral arguments, we're going to talk a little bit about some matters for next week's status conference. Just one thing I want to bring up. So if I forget about that, if the lawyers are in the courtroom, or if Mr. Cool or Mr. Gamble, who I think Mr. Cool is scheduled to present the oral argument for the defendants, just remind me, hey, Judge, you were going to say something about next week. Hopefully I'll remember, but if I don't, the assistance of our capable counsel would be greatly appreciated. Does anyone wish to be heard before we proceed into the oral arguments? And then for counsel who are here in the courtroom, if you can, we'll need you to go to the podium. That's just the easiest for everybody to pick everything up. Anybody who's not in the courtroom wish to be heard or to indicate anything on the record? All right, no one so indicating. And Ms. Team, if as we're proceeding, if a lawyer indicates that they have that they raise their hand or some indication that they want to be heard, if you could let me know, please interrupt. And Mr. Trudell, just like yesterday, if you can't make out what we're saying, if you could please interrupt, and so we can make sure we get the complete record based on the excellent work that I know you'll be doing on the case. All right. All right, plaintiffs.
Good afternoon, Your Honor. Again, Jason Thompson appearing on behalf of the class. Your Honor's read the brief, and I believe everything that we wanted to say is in the brief. My only points I think that I'd like to make for today is to respond to the state's brief. Good. And I believe that they've essentially erected two straw man arguments, and then, of course, proceeded to knock them down in glorious fashion. The two straw man arguments are, one, that we're seeking to disqualify Nate Gamble, and number two, that we're obligated to prove Nate Gamble is at fault for the dam flood. Neither one of those are valid arguments. Number one, we are not seeking to disqualify Mr. Gamble.
How is that? How can that be? That's not the ultimate. If you're saying he is a necessary and essential witness, how does that end in any, if you're correct, then how is it anything other than he has to be excluded from being the lead counsel or counsel for any purposes?
Right. Two reasons. Number one, the phraseology from the rule of professional conduct that's been briefed is likely necessary witness. We haven't taken the deposition yet, and I can see my way perfectly clear to seeing a pathway where we take Mr. Gamble's deposition and we find out if indeed he's necessary. At this point, he's likely necessary, has been the threshold that we've used in our briefing, but that's not the same as necessary. The argument that we've got from defense counsel is that this is just a ruse to try to disqualify Mr. Gamble. I'm here to tell you today that is absolutely wrong. We are not seeking to disqualify him. Once we get done with the deposition, if the defense is correct, and we are then going to come back in front of the court where we have not demonstrated that he's a necessary witness and seek to disqualify him, that's going to be a ridiculous moment for me to stand before Your Honor and do. We very well may get through the deposition and find out that he's not. And we may find out that there are other witnesses that can cover the subject matter. They're the ones that listed him on their discovery responses or as somebody who has knowledge of these events. And so all we're looking to do is take the deposition. I think we have the proverbial cart before the horse, and that's what concerns me.
So this year, I've been a lawyer for 40 years. And I've had the privilege of doing a lot of different things. Litigation, in-house counsel. Most of my friends probably say outhouse counsel mainly, but so like many of the lawyers in this case, like you, like Mr. Dubin, like who are here in court today, like Mr. Cool, Mr. Gamble, Ms. Almonroad, done a lot of stuff. I've never seen in 40 years a party say, I want to depose my opposing lead counsel. I've just, and I'm not suggesting that I think that there's no provision for this. I get that there can be, but I am having trouble getting my brain around how when you haven't seen something in 40 years, it's sort of this is kind of weird. And that's, from the great holding of Redford versus Redford, but so that's no authority, I get. But let me just, I'm going to list some names and I want to know whether they've been deposed, notice for deposition, or interrogatories given.
What do you mean by the last one? I mean,
Whether, and the plaintiffs have said, we are noticing this person's deposition, okay? Or we've given interrogatories to our opposing parties and said, we want them to answer these specific witnesses, okay?
Yeah.
So here's the names. Luke Trumbull, anyone from the Spicer Group, anyone from Boyce, Lee Mueller, Mario Fusco, Jim Pulaski, D. Perky Pyle, I think, Michelle Mueller, or Ron Hansen. Have any of those people been deposed?
all of those names ring familiar with me, knowing the background of the case. I can tell you the answer to the first question is clearly no, because we haven't taken any depositions yet. And perhaps that is, let me finish answering the rest of your questions. Have they been deposed? Have they been noticed? Yes, there have been notices that we've adjourned them because we're still getting through the documents, which is thankfully done now. The 30,000 documents have been reviewed. We are in the process of finalizing the
30,000 documents or 30,000 pages?
documents is my understanding.
Yes.
Yeah,
How
it's
many
been
pages?
massive. I
About?
couldn't even, terabytes.
Couple
It's all
million.
electronic. I can't even tell you.
All right.
We've had a team and counsel that have been hired for this. We're almost near the process of working out the subpoena production from Four Lakes Task Force. And as I understand it, we've essentially exhausted the request with FERC. So I think the universe now is under control. Obviously, we want to have looked at documents before we take depositions, and that's what's been holding us up. So
Yeah,
no
I mean,
depth.
I get that, and I think everybody gets that, but when we haven't taken any depositions, I mean, I'm assuming you're gonna be at some point asking to depose Mr. Gamble. Is that correct?
Absolutely, but I will offer this, in light of the path that we're headed down right now and the realities where we find ourselves. He doesn't need to be the first witness we depose. Certainly, we don't need to start with him. And perhaps what we do is we go through a lot of those names that you just identified. A lot of those people are on the exhibits that we've produced to your honor. Sure.
Right. I mean, that's the thing, Mr. Thompson, I appreciate what everybody is seeking to do on behalf of their clients. I truly do. And I know that this is a very serious case for everybody who's involved, the departments, the residents of these four lakes, the two particularly. So I am grateful that we have capable and spirited advocates, but when, I read those emails, I read some of the arguments related to the emails. One of the arguments was proffered along the lines of that we know Mr. Gamble to be a necessary witness. And this, I'm paraphrasing, I'm not reading, so I'm sure it was much more clearly stated in the submission, then I'm going to summarize it as. But it's along the lines of, there's an email that says he told people to communicate to him because not to the litigants. And I thought, oh, when I read the brief, I thought, oh my gosh. And so, but then when I get down to the actual email that it was referring to, it was basically, hey, we've got, again, this is Jim Redford paraphrasing. There's ongoing litigation. They're the other party, go through counsel. And I thought to myself, well, yeah, I mean, that's exactly what I would have told my clients. But that wouldn't make me a witness in the case. It would make me the lawyer on behalf of my clients, and in this case, the agency. So I'm yeah,
it's premature to know at this point. And my argument to the court that it's premature to conclude that we're going to move to disqualify him is equally as applicable to it's premature for me to demand his deposition today. We need to start the process. Let's back this whole train up.
Okay.
There were witness lists filed.
the lawyers in court know my spouse had a canceled flight today, so my cell phone just rang or dinged.
Did the
if I
part
look-
arrive
I
from
look
Chicago?
distracted, so the eagle has landed, let's put it that way.
Good,
So
good.
there is at least predictability in the Redford household right now, if not happiness. So that's why I was distracted for a minute looking at a phone, if that's what it's showing on the internet. I interrupted you, Mr. Thompson. I apologize.
Yeah, as I was saying, it would be premature for us to demand the deposition today. I think when we back this train up, what happened was we listed Mr. Gamble. Clearly, the state identified Mr. Gamble as a witness in their discovery request. Okay,
As a witness or as someone who, in response to persons who might have knowledge about it?
well, to be more exact, as a person who has knowledge on it. Now, I don't think it's odd for
I assume you have a fair amount of knowledge, and Mr. Dubin.
but we didn't list
I think
us.
My law clerk probably has it. We'd have
We-
to list their names.
Yeah, but in all fairness, we didn't list Mr. Dubin or myself in answers to discovery requests. The state did that for some reason. And so we wanted to make sure if need be, we would explore that. I'll also say that without spending an inordinate amount of time on what it means in this case, for Mr. Gamble, to be involved, this is a person of some authority, to put it mildly. And you'll also see emails from Mr. Trumbull and other people stepping back and not following up with Boyce to go look at the dam and discuss safety issues because Mr. Gamble or his office was supposed to be coordinating it. Now, again, this may not rise to anything, but my goodness, there's certainly in a case where the accusation is that nobody paid attention to the red flags and the alarm bells. And the dam owner is saying, come on down, let's look at this dam that's failing that I've lost control of because FERC says it's unsafe. This is not a stretch to think that there might be some need there. But again, I'll come back to it's timing. We do not need to start there. We simply followed the court's instruction, filed the brief. We're not looking to compel the deposition today. We certainly don't want a protective order precluding it in perpetuity to come out of this proceeding. But I would suggest that we start with the many other easy depositions first. And if it need be, come back to the court and explain why he's necessary. My guess is, like you, I haven't had 40-some years, but I've had over 30 years. This probably isn't going to happen. But we wanted to make sure we followed the court's instruction, filed the brief, we've listed them, and that's where we're at.
Have you ever, in your 30 years, listed an opposing counsel as a likely witness or possible witness? Because I just don't have.
I'm stretching my memory back, and it seems like in one instance, it was a attorney that had left the case, maybe, that wasn't currently on the case. But I'll also tell you, I've never had a situation where a party identified a current defense attorney as someone with knowledge. Why did they do that? And if they do call him as a witness, Your Honor, how do I cross-examine him without a deposition under oath, right? That could become important. But we're not there yet. Again, I would return back to it's premature. For today's purposes, we need not decide this. We complied with the court's request and laid out our cards. And I think the best course of action will be to start with the other depths. And if we get to this bridge, we can cross it then.
All right, thank you. Mr. Dubin?
Have nothing, Robert.
Okay,
Thank you.
all right. Do any other plaintiffs, counsel wish to be heard? I know that may not have been in the playbook for today, but does anybody wish to be heard further? Okay, no one's indicating that I can see the squares of, and Ms. Team has not indicated that someone is indicating it now. All right, on behalf of the state of Michigan.
Good afternoon, Your Honor. Always a pleasure.
Yes, nice to see you, Mr. Cole.
Mr.
And Mr.
Attorney
Gamble, I
General,
see it. I think if that's not a cutout, it looks like it's Mr. Gamble in the background. That'd be
It is,
just
sir.
great. Okay,
It is.
all right.
I
And
think
again, I should have said something earlier. I said it to the lawyers in the courtroom. Yesterday, my assistant, I've been so lucky to be able to work with her for so many years in different places. She came in and said, Judge, do you want to offer everybody the chance to attend by Zoom? I said, oh my gosh, why didn't I think of that? And so y'all got my order last Friday. I apologize for not using my brain for something other than a hat rack when I issued the order, because I should have said anybody could appear by Zoom. That was a mistake on my part, and it's been delightful to speak with counsel who are here. They're probably wishing that I had been a little smarter, and I wish I had been smarter, but that was an oversight on my part. But I wasn't going to adjourn the hearing, but I should have said Zoom was good for everybody. So my apologies to particularly the two lawyers who are here, but to the others. So, Mr. Cole, please proceed.
after driving home last night and the perils that undertook and knowing what the weather was supposed to be today, we do appreciate Your Honor sending out that order.
Yeah, these poor guys that had to fly in were not so fortunate because of my failure to plan properly. Please go ahead.
Your Honor, you're correct. You don't just get to depose opposing counsel. I think what we've heard today is some furious backtracking by plaintiff's counsel. They could have taken the opportunity in the lengthy briefs they've submitted to say, oh no, we weren't going to start with Mr. Gamble as a witness, but that's not what they said. They said he was a likely witness and accused him of heading up some type of scheme to put litigation over the dam safety. This is wholly without merit, and frankly, we're angry at this attempt at what they're trying to do. Because clearly, as Your Honor said, what they're trying to do is disqualify Mr. Gamble.
Mr.
And you don't just get to do that.
No, let me ask you a question. Brother counsel says, Judge, they're the ones that said their lead counsel had information related to the case. And I do not have, just the way our courtroom is configured, it's not easy for me to get digital access to everything during a hearing. I've got lots of papers, but I don't have all the earlier disclosures. What is the people's position? What's the department's position on that? I mean, in earlier disclosures, did you make did the departments make such a response?
Hey, Your Honor, can I speak to Mr. Gamble for just a second? Because we're trying to understand what document that plaintiffs are relying on. Could I speak to him just for 1 second?
You may, but I'd ask you to put your device on mute so that we don't listen in. And
Absolutely.
you can have a minute. Any objection? Do you have okay, hold on. Counsel has, he can give us a cite.
Your Honor, we're referring to the state defendant's answers to joint interrogatories. And it's dated May 13th, 2024. And this particular interrogatory and answer is number 4.
Thank you. I appreciate that.
Thank you.
My understanding, that is when the Attorney General's office was still a defendant in the case. That is no longer the case, and therefore that answer is no longer relevant or cannot be used as the basis for asserting that Mr. Gamble has relevant, non-privileged information
Okay,
regarding.
hold on a sec. Mr. Thompson, do you agree that the AG was, or the Department of Attorney General? My recollection is the department and or the Attorney General herself were defendants or was a defendant previously, correct?
They certainly were never in our case due to the fact that this is a consolidated matter. I read for the first time, the state's response that the subrogation plaintiffs had named, the Attorney General. And so, I don't know what the status of that is, frankly, because that's not my case.
Okay, do you have that document?
I do.
May I see it?
May I
please?
approach?
Please do. Okay, so in the document that Mr. Thompson was kind enough to provide me at page 3, interrogatory number 4 states, please set forth by name, if no longer employed with the defendant, their last known address and phone number and job title of each and every state of Michigan employee representative, employee / representative, including but not limited to MDEQ, Eagle, DNR, and the Department of Attorney General, who was involved in the decision to authorize Boyce Hydro to raise water levels in Wixom Lake in February / March 2020. The answer is at the bottom of page 3. The following DNR Fisheries Division staff made recommendations to Eagle on the permit application to raise the Wixom Lake water level to normal summer pool elevation during the spring of 2020, Jessica Mystic, a DNR supervisor in fisheries, Jeffrey Jolly, DNR supervisor in fisheries. And then it says the following Eagle WRD staff made recommendations or provided comments on the permit application to raise the Wixom Lake water level to normal summer pool elevation during the spring of 2020. Brian Rudolph, Eagle, the Bay City District Supervisor in Water Resources, Lucas Trumbull, Eagle Supervisor of Dam Safety Unit in Water Resource Division, Helena Nelson, Environmental Quality Specialist, David Pingle, Supervisor, Enforcement Unit, Nathan Gamble, Assistant Attorney General, provided legal counsel to Eagle and DNR. And then it says these individuals can be contacted through counsel for state defendants. Okay. Is that the only place, Mr. Thompson? And I know this is Mr. Kuhl's opportunity for oral comments to the court, but is Mr. Gamble identified anywhere else?
I do not believe so. That's all that I've seen.
Okay, thank you. All right. All right, having the benefit of that granularity, Mr. Kuhl, you may proceed.
I think that goes directly to one of our primary points, Your Honor, which is you just don't get to depose opposing counsel. You have to show that the attorney had non-privileged information on a relevant issue that cannot be obtained from other competent witnesses. And they haven't made any such showing on any of those issues. The topic that you just went goes to privilege. They can only obtain non-privileged information. Mr. Gamble provided legal advice. Boyce Hydro had a lengthy list of legal problems, and Mr. Gamble represented the state on some of those issues. But he was acting as an attorney. There's been no showing that he acted outside of that scope. Everything that Mr. Gamble did, the advice that he gave to Eagle, to DNR, the thoughts he had about how the litigation should be structured, those are all privileged information. There has not been any showing by plaintiffs that there is any non-privileged information that Mr. Gamble may possess that would be subject to discovery. So clearly, they have failed to show that he is going to be a necessary witness on that topic. And not only that, I think on this topic, as your Honor knows from the People v. Petrie case, opposing counsel may only be listed as a necessary witness when a party offers a particularized basis demonstrating that their testimony would be material to the claim. They haven't made any such particularized showing. They've made some general allegations, but nothing specific. They've offered, if you've read the exhibits that they've posted or provided, there is no particularized showing on any of these bases. There is zero evidence. They accused Mr. Gamble in their reply brief of prioritizing litigation over muscle studies and other issues over the known dam safety problems at Bryce Hydro. That's a pretty damning allegation if you're going to prioritize muscle litigation over dam safety. You would think if counsel is going to make such an allegation, they'd have some evidence to back it up. But there's none. This is a figment of their imagination. They have made no showing whatsoever that there was any such decision that was made. And they've certainly made no showing, as I've already said, there would be non-privileged information that they could obtain from Mr. Gamble on that. If they want to pursue this theory, there are plenty of people from the state for them to depose. As you have already identified, and you look at the exhibits that they provided, there are many personnel from Eagle and DNR that were involved in the actual decisions, not Mr. Gamble, on the topics raised in plaintiff's motion. There are plenty of other witnesses that they should be deposing, and that's where they should start. Yet they haven't deposed a single one of them yet. Not one. And that failure demonstrates what this is all about, which is this is about plaintiffs trying to get a tactical advantage by getting Mr. Gamble disqualified as trial counsel. And the Supreme Court has warned about the dangers of permitting such action. If you just ask the court to heed those warnings, to ensure that any action taken by plaintiffs meets their burden of proof, and frankly, at least at this time, because they have not made that showing, that they strike Mr. Gamble from their witness list.
Have you made such motion?
We have not made a motion at this time, but I think that's, in my understanding, that's what the court's request of plaintiff was aimed at, making them try to justify why Mr. Gamble was on their list.
The court's goal is to get the case completed fairly, fully, and with both sides having the opportunity to present their claims and cases. And I saw as an impediment a sort of Damocles over the litigation in the possibility that the lead counsel for one of the parties could potentially be a witness. That's all I'm trying to get to a point where this case can be decided either by motion or substantively after trial. And all the lawyers have heard me say it many times. I'm the fifth judge who's had the privilege of serving in this case at the trial court level. I'd like to be the last judge, and then let the Court of Appeals or the Supreme Court correct all my errors. That's fine. But that's what I was trying to do. But there is not a motion to disqualify, or I'm sorry, to strike him from the witness list. that I'm aware of at this time. Anything else, Mr. Cool?
No, we thank you for your time on this, Your Honor. And as I said, I think plaintiffs have already agreed that perhaps they need to gather further information before they decide to proceed on this. And that's perhaps the best outcome.
Right. Yes, I'm Mr. Dubin or Mr. Thompson, please.
A couple matters or points that perhaps might facilitate the court. I'll repeat, we are not seeking to disqualify Mr. Gamble. I appreciate the court's view of the juggernaut that we might be in could lead to that or might necessarily lead to that. But after hearing argument from brother counsel, I want to repeat again, that is not the goal. Number two, there is no motion to strike. There is no motion to disqualify. We simply have a witness list. Number three, again, I can assure you that we will start with all of the other depositions, and we're not going to be asking to take Mr. Gamble's deposition first. It was not in the filings with the court, and it's not our goal, and it's not our plan. I think this will resolve itself. Perhaps my fourth point indicates that it is resolving itself, because I did not appreciate, Mr. Dubin did not appreciate, no one that I have talked to in preparation for today appreciated that the May 2024 answer to discovery requests applied to the subrogation plaintiffs, and their complaint included the Attorney General. It would seem to me to be a simple request by us to have the court request defense counsel remove Mr. Gamble from that answer. As the Attorney General has been removed from this case, the subrogation plaintiff's complaint has been dismissed. We never sued the Attorney General, and it would seem to be a simple step forward, and perhaps a significant step forward, to eliminate Mr. Gamble as a named witness, a named person with knowledge for interrogatory number 4. Thank you, Your Honor.
Mr. Cool, do the department defendants wish to have leave of the court to file a supplemental answer to interrogatory number 4 that the court went over, thanks to Mr. Thompson having it with him? Is there any desire by the departments to modify interrogatory number 4 in light of the Attorney General and or the Department of Attorney General no longer being defendants?
Absolutely. I think that would be a fine way to proceed, Your Honor.
Any objection, Mr. Thompson? No, Your Honor. How much time would you require, Mr. Cool, to, together with Mr. Gamble, make such a modification?
I don't think it would take long. Maybe we could have a week.
Okay. We've got a status conference next, is it Tuesday or Wednesday? Oh, okay. It's not next week. It's okay. See, I didn't want to delay this. That's why I didn't want to grant you the leave. Okay, let me see if I can get my calendar to cooperate.
I think the status conference is on the 3rd, Your Honor.
Yep, that's what brother counsel said here in the courtroom. I apologize for my faulty memory. So yeah, a week from today, if the defendants wish to modify the answer to interrogatory number 4 as relates to Mr. Gamble or anything else in that interrogatory answer that was filed on May 13th, 2024, at a time when the department was a defendant, then you may do so. You have 1 week from today, close of business. Provided there are no more blizzards, hurricanes, or other acts of natural disaster that end up in canceled flights and all sorts of other things.
Thank you, Your Honor.
Okay. Anything else on this topic for Mr. Thompson or Mr. Dubin?
No.
Any of the attorneys who represent any of the plaintiffs, anything else on this topic from anyone that were on the motion and the responses? All right, from the defense, anything else on this topic?
not on this topic. Just as a reminder, you asked us to remind you to bring up the status conference.
Right. You're clairvoyant, Mr. Cool, as usual, just like all the other fine lawyers in this case. Okay, right. Here's the thing. We've had many opportunities for discussions and for the court to receive the counsel and advice of counsel. And I asked at one recently what the status of discussions with the mediator that the parties had selected was. And I was advised that there were no ongoing discussions. Again, I'm summarizing. And there was some belief that that just wasn't going to happen until after summary disposition motions or after some more discovery or something along those lines. So I fully recognize the parties have the right to choose, with the court's approval, a mediator, a facilitator, and you have a right to choose how you want to proceed with them. I don't presume to have the expertise, wisdom, or knowledge that the facilitator that the parties have chosen possesses. I do not presume to have those qualities. However, I do have the authority to require the parties to participate in court-ordered settlement conferences with a judicial officer. And so what I want the parties to be aware of is that on the 3rd, when we reconvene, I think it's mainly by Zoom this time. There might be some in person. I just don't have a specific memory right now. I've got so whatever, is it both in person and Zoom or? Oh, okay, great. Oh, good. Okay. No, I don't, however it is, I'll look forward to seeing everybody. But between now and then, the parties are going to contact one another. And Miss Almond Road was sort of burdened with being the quarterback of the plaintiffs team for communications with the defendants. So I would like Miss Almond Road or some other emissary on behalf of the plaintiffs to speak with Mr. Gamble or Mr. Cool. And I want to get some meetings scheduled with your facilitator. If I do not have specific dates during the month of March, which the parties and the lawyers will be meeting in person or by Zoom, however the facilitator determines it's appropriate, to substantively address this case sometime in March 2025, then the court, if you don't do that, that's fine. That's your decision. But I am telling you now, you will be ordered to a settlement conference with a judicial officer who is not, it has no conflicts in this case, which will take place in April. And this will not be a voluntary decision on your part. This will be my order requiring the parties and their lawyers, and I don't mean all 3,000 plaintiffs. I mean class representatives, attorneys for the people and the defense. I won't go into the specific details of who I would envision the defendants would be required to bring, but certainly Mr. Gamble and then whoever is on his legal team, but there would be representatives with the authority to settle. I will be requiring this. The reason for this is it is my firmly held belief that statistically, a review of the number of civil cases filed in any court in the United States of America reveals beyond pre-adventure that the astronomically vast number of cases settle. no matter how hardened the positions are, no matter how strongly held and articulated and advocated the positions are, the vast majority are settled as opposed to go to trial. It is a fact of American jurisprudence. The advantage is the parties are able to write the chapters which are their own story, and it moves the process forward. Waiting, as was suggested to me, at least that's the way I heard it at our last discussions, is unwise in my estimation. I am the judge that you have the misfortune of having been assigned this case. And so my judgment, I believe, on this is what is going to control the day, at least as far as this step of the process. That doesn't mean we're not going to litigate motions. Doesn't mean we're not going to take discovery. It doesn't mean we're not going to do a whole bunch of other things. But that is something, and I wanted you to know about this today, so you have a week and a half to try to figure out some dates, because I don't want to get in the way of how you want to do it. But if how you want to do it is we're waiting, that's not going to work on my docket. And I'm sorry for the inconvenience. I don't want to require another judicial officer to get fully schooled up on this case. I hope that you all can move forward collectively, collaboratively. But if you're not able to, for whatever reason, I'm going to help the process. And that's Jim Redford's definition of the word help, not the lawyer's definition of the word help. So thank you, Mr. Cool, for reminding me. But that's what on February 3rd, among whatever else we're going to talk about, I want to talk about that. And so, I would be happy to give the opportunity. Oh, I am not surprised to see Ms. Almonroad raising her hand. It is so good to see you today, ma'am. I would be delighted to hear what you have to say. I can't hear anything, but you're
Okay,
not
it's
on
nice
mute.
Now,
Thank
can you hear me?
Yes, ma'am.
It's nice to see you today as well.
Thank
And
you.
the plaintiffs.
Happy New Year to everybody.
On behalf of the plaintiffs, we welcome the opportunity to proceed with facilitation in this case. And I just wanted a little further clarification. Are there any number of, I understand that it will wind up being what we can actually coordinate, but do you have in mind how many dates we need to have?
Yeah, thank you. That's I have thought about it. Less than one is not enough. More than five is too many. When I was thinking about what I was going to require you to have for me on February 3rd, the number that kept coming back to me is, Jim, when I'm speaking to myself, okay, you gotta have them meet at least twice. Because the first time it just, in a case of this magnitude, more than, and then I thought, well, maybe more than twice, but then I thought about who our the outstanding facilitator you have is, and I know he's got a huge busy docket. So the likelihood of getting 3 dates with him, and I'm not saying, if you came back and said, I'd really like to hear you have 2 meetings scheduled, one in March, one in April. That to me would be success. And then I'm going to step back and I'm going to do the judge thing. You guys do the lawyer thing with the facilitator, so you can make steps towards resolution. So 2 would be ideal in my estimation. If you have at least 1, I will withhold making an immediate referral to a judicial officer who has already agreed to assist the parties and the court in this process. It's not an active judge of the Michigan Court of Claims because of a variety of reasons, but with consultation with the chief judge of the Court of Appeals and the chief judge of the Court of Claims, there is a judicial officer currently serving who has demonstrated and indicated a willingness to help. So I don't know if I've said rambled. I apologize. Does that answer your question, Ms. Almonroad?
Yes, it does, Your Honor.
Do you have any other questions, ma'am?
not at present.
Okay, anybody else, any other plaintiffs? Mr. Thompson, Mr. Dubin? They're indicating no. Anyone else in the, I guess it's the gallery of the Zoom meeting wish to be heard from the plaintiffs? All right, Mr. Cool or Mr. Gamble, would you like to be heard from the defendant's position?
No, at this time, we're more than happy to speak with plaintiff's counsel and see what can be arranged.
Okay, thanks. Mr. Gamble, good with that?
Yes, Your Honor, thank you.
Okay, thank you. All right. Everybody stay in place. I'm going to talk with one of my attorney advisors. But Mr. Trudell, if we could stay on the record, I'm just going to go talk for just a moment. I want to make sure I have covered that which I need to, but I'm going to be not visible on the computer, on the screen. Okay, so we're not in recess, but I'm stepping away from the bench for just a minute. Thank you. All right, continuing on the record, and it's 2:48 p.m. I don't have anything further other than right now there's a motion before the court on the necessary witness issue. The state is has a week to supplement their answers to an interrogatory. I am going to wait to issue any opinion or order related to these motions until we have a chance to chat briefly about this at the status conference and find out whether or not do you need a decision? Do you need an opinion order? Or has it become moot, or is it withdrawn? Or, we cross that bridge together as we walk towards, resolution in this case. That's satisfactory, Mr. Thompson?
Very much so.
Mr. Cool, is that satisfactory?
Absolutely. Yes, Your Honor.
All right. One final pass. Anybody have anything before we recess for the afternoon? All right. And again, I apologize. I really am. I don't know what I just wasn't thinking on Friday last week. I wish I would have had the good sense to offer Zoom attendance by everybody, but it was very nice to see Mr. Dubin and Mr. Thompson today. And I wish a happy afternoon and a pleasant day for the rest of the parties and the lawyers who are here. And Mr. Trudell, thank you so much again for your service. I don't think I have any hearings with you tomorrow, but if we are together, I'll see you then. So.
Sounds good. Thank you.
Okay, time is 49 minutes after the hour 2, so 2:49 p.m. Today is January 22nd and 2025. The court is in recess. Thank you. Have a good day, everyone. Bye.
Thank you, Your
Thank
Honor.
you.
Thanks. All right, gentlemen, continue about your business. Thanks. All right.